Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass.
Good evening, folks. We have the team here tonight. We're all here. Well, some of us are all here. I'll give my disclaimer. I'm not an attorney and I'm not all here. But we have Christopher Hallett over there. And
that's okay. I'm still not all here. And just ask anybody that knows me, they'll tell you.
I'm just not making any unsubstantiated claims here tonight.
Right.
Thank you for joining us, folks. And we have John Gentry with us tonight. How you doing, brother?
Doing tonight. Yeah.
Running a little behind. I was actually out back digging in the irrigation ditch, trying to get that all cleaned up and stuff. And Ted sent me a message. Hey, where you at? Oh, that's right. Got the show tonight. We got water coming in the ditch here in just a few days, so we only get like a few days for the break in the weather before the water comes in. So,
right,
we got to get on it. So
it's amazing. Like it's on you, and you're not even paying attention.
Yep. So, welcome to the show tonight, folks. I really don't know of a major topic that we're going to talk about. I think I brought my little USB stick down with some blank templates, document templates, and was going to kind of put that in and do a screen share, but I'm going to try anyway. This machine doesn't have Microsoft Office on it, but I know John might have some stuff over there. I want to see if this will come up.
Yeah, it's been a crazy busy week for, I think, pretty much every one of us. Oh, Lord. Going back to, how we've been working on these different projects we've been working on, and, now all this stuff is pretty much all done and it's coming to fruition now. It's like, for excuse me, the last 2 years has really been killing me that I haven't been able to say much, just because of the nature of the way practice works. So, and there's, a multitude of other reasons out there as to why, you should keep it quiet too, but too many things are happening now to be coincidence, and it's a matter of you can't deny the similarities. When you start hearing the language out of Washington D.C., that's the language you've been using for the last 2-3 years, it's like, well, I'm not going to be able to deny that one for too much longer.
What a quinky-dink,
Right?
Want to give thanks out to our promoter over there, our producer, Ted Fogg, just so y'all know. Love you, brother. Thanks for doing what you do and making this all happen the way it does.
Absolutely,
You're welcome.
Bro.
Thank you guys for continuing to do it. It's something I think that should be, it's something solid within our community, hearing you guys talk, and sometimes it's really to the point, and sometimes you guys almost argue about different things and it's drawn out. But either way, it's something that everybody can get. You could get something from this show every time you watch it.
Right. I'll have to admit, there's some times that I go back and like, what was that Chris was saying?
Yeah.
Sure.
And I go back and rewatch certain parts of the show just to see what was it he said there, instead of calling him. And that's what, that's the reason why these videos are archived the way they are, so that you can come back and watch them anytime. But some things that we've been talking about in the background here is with Ted's skill set over there and cutting and pasting and doing all that kind of stuff with videos, editing. We're going to just do like short little clips here. Some, 3 to 5 minutes, some 15 minutes. But like what I actually did pull this up, so I think it's going to work. I'm just kind of just show you what a document looks like and how to do it, and just the short little stuff. This definitely will get you in the door, so you can be heard. From there, you can make oral motions and stuff, and then you get into the heavier stuff, which is, the briefs, memorandums, and points of authority. But basic, notice of appearance, notice of special appearance, because, I've talked about this before, is, remember back in grade school, you had to raise your hand to be heard. And some of you out there may know this and have experienced this, and the judge will tell you, I'm not going to listen to you. You're not going to be heard here. Why? Because you haven't put them on notice of how you are appearing. So they don't recognize you. You haven't raised your hand yet. And then the second part of raising your hand is properly filing your motions. While us pro se litigants, sui juris, aren't supposed to be held to the same standards as an attorney, as long as the substance of your document gets the point across that you're doing a motion for dismissal, or, here's your affirmative defenses and counterclaims, you're responding to something, or, making your own petition. I mean, it's pretty much the same thing. Just kind of a simple where it happened, all the jurisdiction, location, and all that stuff. And you have to give them, you have to tell them what jurisdiction. That's the thing about doing motions for dismissal for lack of jurisdiction, is whatever is quoted in here is the jurisdiction that's being claimed that they're coming into court, coming into court for and under. And if you don't like that, I don't want to consent to this kind of forum and this procedure, this process. You have the right to object to that. You have the right to say, no, I don't consent to that, because everything is about consent. But there's a legal term out there that's called latches. So kind of even what goes along with the legal maxim of law, core concept of law, a lazy man loses. So if you don't timely respond, most things are 21 days. So when you're initially served with something, some sort of motion, whatever, an initial petition, generally speaking, it's 21 days to respond. Now, what you can do is you can file a continuance. If you file anything other than a continuance, you lose. Latches occurs.
Right. Well, the other thing too is there are states and jurisdictions that's less than 21 days.
It depends on what it is.
Well, again, because I've heard of instances where it's actually either, as low as 10 days to respond. Even like you said, even if it's just a motion to extend time.
Right.
Just what I said, you have to just say, okay, I hear you, but I need more time to write my objection. So,
right.
And again, that's why I say, it's something simple. And I was having a conversation the other day with with another mom that's, actually starting to see some enforcement in her particular case.
Right.
And her particular issue is complicated because in her state, media is two-party consent. In other words, both sides have to consent in order for that media to be admissible in court. Now, where it presents the problem with social media, if she would come out and say, hey, blah, 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 blah on social media, the other side didn't consent, um, then what that could ultimately do is hurt the prosecutor's case. So if you do find yourself where you are going to start getting active enforcement, one of the things you might want to do is just send a request for recommendation to the prosecutor, like maybe request a meeting. But in your request, you just simply ask them, is there anything that I should avoid or you would like to not, see me not do that could hurt your case? And basically, in other words, what can I do or not do to help you get to the end of this thing as fast as possible? And two things happen there. Number one, you're developing a relationship with a person that is probably been lied to about you, and you can expect that. The other thing, when they start to get those types of requests, they're going, this person is nothing like what I was told they're like. And they might give you a short response or a short audience. And when if you're lucky enough to get that, you just go and say, look, I know you're busy. I'm not going to take a whole bunch of your time. But if there's anything that you, anything I shouldn't do, I mean, I don't want to jump in your way. So, you tell me what I need to avoid, and I'll make sure that those things don't happen. And you can pretty much be guaranteed you're probably going to end up with a maybe not necessarily a conviction out of it, but you will get some form of a settlement that will be more amicable in your particular situation. So, I mean, just because there's an indictment doesn't necessarily mean there's going to be a criminal conviction. Mm-hmm. A lot of times those things end up in a plea bargain. So that said, you've got somebody who will be much more motivated to be a little more aggressive on your behalf. So, and again, that's, just being reasonable and not being the person that has been, that they're claiming you are. So, just a little tidbit from, some stuff I'm seeing over since we were here last week. But anyway, what do you guys want to jump in and talk about there?
Well, I was going to pull this up because it is working.
Let's get Ted back and just to kind of introduce the viewers out there to a new process that we're going to do on Mondays. We're gonna take a little 3-minute segment and we're going to post on how to do something. And I guess our first one tonight is writing a motion and a supporting memorandum of law. And then we'll kind of run through that, and then that'll be a separate video. It'll be like a 2-3 minute thing that you guys can search and refer back to about how to write a simple document. So as soon as Ted gets back here, I think we can jump on that.
Well, I was going to kind of start at the very beginning here, your notice of appearance, and kind of just show you mine. I mean, we're just talking like a simple 1-page document. So this is the generic process for everybody, as far as I understand. Reading rules, you have to raise your hand. You have to tell them who you are. You have to put them on notice of who you are. So this is actually downloaded basically from my Idaho Supreme Court. So let's see if that brought that up. Of course, maybe I shouldn't have my phone number on there. Let's see, does that come up? You guys seeing that?
Yep.
Sure.
It's working this time. Okay. All right. So this right here is just a basic notice of special appearance. You'll have to look in your rules of procedure. It'll give you the rule. Whatever your style is, the layout here, this is the layout for Idaho. In the district court for the 3rd Judicial District for the state of Idaho and for the county of Canyon. So that's out of Canyon County. That was where the protection order hearing was at. Now some things up here, you got to have your name somewhere, your address, phone number, of course, all that good stuff. Now you have my stuff. But you'll notice here I have impropriety persona and sui juris and in personam, and then e-clause LLC. Those are all terms, legal terms for them to address me as. And then to the clerk of the above district court, that's actually part of the original document, all of this right here. And all I had to fill in was the third, and the county of Canyon was the only two things I had to fill in up there. Got to put in the case number. And pretty much any of your court documents, this section right here can be changed to whatever title the document is. That could be motion for dismissal. That could be motion to strike, motion to vacate an order. This is your title. This is whatever it is. And when you find your rules of procedure, it'll tell you, motion to do this. That's what the title is. You quote exactly what it says in the rule. Motion to do this. Or if it's a petition is usually the part that starts the case. And then motions are what's made part of motion practice. Motions are made after you start the initial petition and the response, affirmative defenses and counterclaims. And this is where you get into your motion for dismissal, because like we've said before, the very first thing is you want to file. I mean, that's what they do to us. Motion for dismissal. When you file something against them, it's an automatic motion for dismissal, because that's just how it goes. That's how you play the game. And hopefully you're able to respond to their stuff. Most of the time, if you get it right in the beginning, there's not going to be much. I mean, they can try. They do try to drag it out. But this notice of special appearance, this goes right along with that motion for dismissal, because you're objecting to the personal jurisdiction, and that's exactly what impropriety persona is all about. So, obviously something that I wrote here, the attorney didn't like this when I said I'm one of the people of the several United States. He brought that up. Oh, something. Yeah, he filed a notice of appearance, something about being one of the people. I'm like, yeah, that's me, one of the people, which means I have authority over you. I'm not just going to be a little limp biscuit over here. You're going to be able to railroad me. I will hold you accountable, because that right there gives you authority. That tells them you're not just some dumb, whatever, vagrant, alien, illegal alien without any rights here. And then,
that's the other thing too, because that goes back to when we talk about your standing in court, right?
Yes, sir.
Remember, when you're looking at the court, look at this from the angle of what do the things in the court mean? For example, a motion. What does a motion do? A motion is requesting that the court take an action based on an event that is consistent with either a rule or a law. And you're going to provide, substantive arguments, stare decisis, which is case precedent, and all these different things to justify why the court should take whatever the action is you're requesting. So, but in order to move the court, you have to have a firmness and standing, right? So, in other words, if you're going to be, if you don't have standing to be in the room, you can't even ask the court to take an action. So when you're filing your notice of appearance, like Kirk says, you're waving your hand, you're also letting the court know, hey, I'm standing here, okay? And in my position in standing here, here is who I am and why I'm standing here. Mm-hmm. So remember, the court is become lazy in that it's used to anybody but the quote unquote attorneys is nothing more than an adorned piece of property, and you're just a piece of crap to be thrown from one end of this son of a bitch to the other, depending on what they feel they can do with you. And one of the things that we're trying to help you guys to understand is that's not the way American jurisprudence is written. And because we can definitively show this, you know, in many of our different angles, it's not a matter of, you know, look, we don't have to prove that the court is in disrepute. You did all the work. You didn't even need any help from us. Our question is, what do you want us to do to help you fix the damn thing? And it was a matter of, you know, it wasn't so much what the question was, it was how we asked the question. And it, you know, from the, again, that position in standing, like, you know, look, I'm not standing here as a torn piece of crap, you know, with all of these allegations. You know, we can prove variously that those have been, you know, unsubstantiated. So again, with my firmness in standing, I said, okay, look, here's what we know. You know it. You know that we know it. What do you want me to do to fix it? And
well, we're trying to make these short, remember?
Right.
Yeah, I was gonna say, let's do a retake on this segment. Is Ted here? Ted, can you come back online? Okay.
Oh, there he is.
So I like, Chris, I loved some of the points that you made. Take out some of the key elements and just say it in like a minute or 30 seconds. And the same thing for you, Kirk. But what I love that you did, Kirk, is go through that document and say, you know, I'm naming myself seri juris in persona. Here's why. Here's this sentence that you want to include in this document. Here's this sentence you want to include in this document. And then a brief, you know, so spend like maybe a minute going over the essentials of the docket. Then spend, you know, maybe another 30 seconds discussing like the legality of it. And then jump over to Chris. And then Chris, you make a couple really concise points about, you know, why this document is important. And so when we're ready to do that, we'll say ready, action. Then Ted is going to mark the time in the video. And then Chris, when you're done, you'll say, you know, okay, cut. And he'll cut out that okay, cut from there, and that'll be the end of the video. And then we'll tag that notice of appearance, why notice of appearance is important, how to file a notice of appearance, and Ted will tag that video with that. Ted, are you good with that? Did we lose Ted again?
No, he's there. He's just no audio. So, okay, so we're marking here. And this is a notice of special appearance. You have to put the court on notice of how you are appearing before court. And so for here in Idaho, this is kind of the format, the header, the heading of a document, for, legal documents. Up here you got, you know, the name, your address, phone number. One of the things that I put in here is I'm listing in propria persona, which means I'm objecting to the personal jurisdiction, which is, you know, the forum and the process. If you don't agree with the process, then that's in propria persona and the jurisdiction. Okay. Sui juris just means that you're of lawful age, of sound mind, and perfectly capable of handling your administrative duties. This is the administrative duties right here. This paperwork. Okay. So, and then in personam is basically, I'm claiming my rights here, and I'm going to be as the movement. I'm going to turn, even if I'm the defendant or the respondent, I'm going to turn this around, and in personam, I'm going to become the petitioner. I'm going to become the moving party. So this is how you turn things around, is that in personam. And then, you know, this in the district court, you know, this is actually downloaded off of Idaho Supreme Court Assistance Office link. And all I had to do was fill in the blanks. I mean, this is something you can even handwrite if you wanted to handwrite it. And then this section right here is the title of the document. Okay. This can be anything in here. This particular one that we're going over right now is your notice of special appearance. And to the clerk of the above district court, that would be this district court here, 3rd Judicial District. Okay, comes now one of the people of the several United States, my name, your name, whatever, natural father of Liam Lee Pendergrass, and respondent in the matter listed above, case number appears specially and not generally in proprietary persona, sui juris and in personam, and as an agent of e-clause to bear witness to any trespass of the law with the assistance of counsel, Christopher Hallett, loss prevention, e-clause LLC, comes before this court under duress, coercion, theft, and under threat of arrest pursuant to. Now, this Idaho Rule of Civil Procedure 4.1b, that's Idaho Rules Civil Procedure. Now, what entails in there under the 4.1b is basically I'm objecting to everything, and you're going to have to prove that stuff, okay? And then it's just date. That's supposed to be date and sign. I don't know what happened over there. Something got, probably messed up in the translation because this doesn't have Microsoft Word. But technically, this should be just like a simple 2-page document. Date, sign, put your name down here underneath of it, okay, in print, and you're supposed to sign up here. Then here's your certificate of service. I certify that on whatever day, whatever month, a true and correct copy of this foregoing was served upon, of the foregoing. The foregoing being notice of special appearance, because that's what's important about your title, okay? And then this is who you are serving. You put letting the court know who you have served. This was served upon. So I like to hand deliver mine because I like to look them in the eye when I hand them this crap. And basically on the bottom of the certificate of service, boom, there's your date and signature. And this is all whacked out. I think it's because of the transition from not having. Okay, so now here's the second document. But before we get into that, Chris, what do you have on notice of special appearance?
Well, your notice of special appearance is informing the court how exactly and why you are appearing. Just because you're standing there in the courtroom does not mean you have admitted to consenting to an attorney of any kind. So, and because we have now pointed to the fact that we know and completely comprehend this, we're getting a whole lot of pushback, which is normal. And, but it's most important that you make sure that the court does clearly understand that you're not standing there as somebody who's consenting to the jurisdiction and as allowing yourself to be attorned. Your position in standing is very important to how the proceeding goes. In other words, when you ask the court to take an action, when you're moving the court, it's that firmness in standing that will assist you over and above everything else you do.
Yeah, we'll get into the motion stuff here next, but I see a question here, and she was asking if this is what she can use to get back into court. No, not typically. No, this is your initial filing. Anytime somebody files a petition on you, this is it. This is the first document you file. If you can't get this done, the only other thing to file is a motion for continuance or laches occurs. Okay, so this is the most important document for everyone to know. Notice of special appearance. It will be in your rules of procedure. I guarantee you.
Also, if you have counsel that has withdrawn, you must file this.
Yes.
So, no matter what counsel did, if you file this, you're informing the court that now we're here, I'm here, we're going to do this my way in accordance with the law and the rules of the court out of respect for the court. And so it's almost like filing a 60B without filing a 60B, if that makes any sense.
Well,
and just real quick for administrative purposes, Ted, did you get my cut on that? So you're going to have to back up about a minute from now. Okay. And then, so take that question out of the video. I mean, it's probably important, but but not related to the specific of how to file a notice of appearance and why, I think.
So I want to touch on this here too. I filed a notice of special appearance regarding and they ignored it. I don't care if they ignore it. You're there to make your record. Okay. This is something that we've talked about before. The initial court that we go into, we know that they're the corrupt court. That's the admiralty. That's an administrator sitting up there using the equity scale. They're not using the scale of justice. And, I don't care what they do. You're there. Forget that they're even there. You do your own thing. This is the first document to let them know who you are and how you are appearing, because you get to tell them who you are and how you are appearing, not them. That even the administrator there, his duty by law, under the law, is to be an umpire, calling balls and strikes. Now, when you're filing a notice of special appearance, you're in propria persona. You're objecting to the jurisdiction. So this is where we get into the Rule 12b motion, okay? This is in conjunction with this notice of special appearance, because that's what in propria persona means.
Also, too, I want to touch on something you did say. When you talked about changing your position from defendant to plaintiff, that's actually based on a legal maxim or a core concept of law. And here it is. Reus excipiendo fit actor. That's Latin, and it means the defendant by plea or exception becomes plaintiff. So very important that you know and understand that these core concepts or legal maxims do play a role in American jurisprudence. I don't give a damn what any attorney tells you. If they tell you they don't, they're full of it. So because the reason it does is the language of Latin is also the language of the church, which is based on our ideology, which we've talked about in previous shows. So that's the reason that these are written in Latin. They're written in the language of the church, which is coincidentally the language of the court. So when you make that transition and the defendant files their 12b motion, underneath your answer to their 12b motion, you have to put respondeat superior, which is Latin meaning let the principal answer. Because if you don't remind the court that you are the principal at that point, and you do have, it is a maxim of law that they do have to allow you to answer that 12b motion. And you can end up losing your position and standing at that point. So again, there's a whole lot of reasons why you want to pay close attention to these maxims of law, because when we do, and now I'm saying when we do, not saying if we do, when we do go back to courts of law, having your record, having everything you've done established in your record, like Kirk says, is going to be very critical for you. So
okay,
with that, take it away, gentlemen.
So
hey, let's do one on motions and memorandums, and I've got a couple quick examples.
Hold on, guys.
Yeah.
This document right here goes with the notice of special appearance. This is all part of it.
Right.
Okay? So we have kind of want to continue in a line of succession here so we don't screw people up.
Okay, so what would you call this next section of the
This is the motion for dismissal. You're objecting to the personal jurisdiction. When you file your notice of special appearance, you're objecting to the personal jurisdiction. You have to move the court for dismissal. And again, we go right back to this is exactly what the other side does to us when we file. It is an automatic Rule 12b motion for dismissal for lack of jurisdiction.
So let's get ready for that, Kirk. Ted?
Yep.
When Kirk tells you action, get a mark on the time, and then do your thing, Kirk.
All right, Mark. This is the next document that is filed in conjunction with, they're two separate documents, but you're going to file your notice of special appearance first. And then I file, I should rephrase all this. I file the notice of special appearance. And then I filed the motion for dismissal right after it at the same time. Okay, so again, we go back to the title of the document, goes over here. At least here in Idaho, this is the way it is. Some others list the names up the top and then the case number, and then it's however it is, you just look at your paperwork. That tells you how it's laid out. And in fact, if you have a scanner, you can scan in a document that you've picked up and turn it right into a document just like this and edit it and change it and do whatever you want with it. I've watched attorneys sit right there and do the same thing. So this is a motion for dismissal where you're trying to move the court to dismiss. Now, when we're talking about objecting to personal jurisdiction or objecting to jurisdiction, period, the burden of proof is on the moving party. So this is where you switch, you're turning things around. Okay, I'm going to become the moving party, and you're going to have to prove that you have proper jurisdiction here. And there's 7 elements of jurisdiction. So there are certain elements that are needed for civil cases, and there's certain elements that are needed for criminal cases. Okay, so this is a basic motion right here, and 12B is a universal. As far as I know, that is universal, federal and state. I haven't found anyone that's not a 12B motion. Okay, so comes now Kirk sui juris. Okay, that I got rid of the impropriety persona first, because now I'm appearing sui juris because I'm taking control of my case. But I'm appearing in sui juris first and then impropriety persona because that's what I'm moving the court. I'm objecting to that jurisdiction. In his proper person, objecting to the jurisdiction, not just personal, the jurisdiction of this court. Pursuant to, here's that pursuant to stuff. Okay, Idaho Rule Civil Procedure, Rule 12B, and intends, see, this is something you have to do in you have to put this in I have to put this in my motions. If you intend to give oral argument, you have to tell them, I intend to give oral argument, and we have to tell them if it's supported by a brief or not. What kind of documents is this motion for dismissal, whatever this motion is, what is it supported by, if anything? So this is all this is just, again, 1-page document. And so here I went into the Rule 12B and I said, okay, lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted. I'm sure those of you who follow this long enough have heard me make that statement. Motion to dismiss with prejudice, as it says right here. Motion to dismiss with prejudice pursuant to Rule 12B. With prejudice means you can't refile. If you can't prove jurisdiction, you don't get to refile. You're done. So you better have your ducks in a row if you're going to file something against me, because this is what you're going to get. You're going to get a notice of special appearance, and you're going to get a motion for dismissal right here. This is what you're going to get. You better be prepared for it. And now, burden of proof is on the moving party. So in my brief down here, it's going to show you, that'll be the next document that we show you. We'll get into the brief part. So when you go into Rule 12B, and these are what's called grounds. Figure out what grounds they are. And you can actually just do, okay, improper venue. What the heck does that mean? Highlight it, copy, paste it up into a web browser, and search for a definition. Most definitions will come up that are almost exactly general definition. It's going to give you the basic idea of what it is. So
remember, too, your grounds, that's the thing you're standing on. So remember the importance of standing. So again,
yes, they're standing. At this point, you're forcing them to prove they're standing. Can they state that claim?
Exactly. You have grounds to stand on to ask them to prove why they have standing, right?
Right.
So again, that's why I said it was just, I just wanted to throw that out there. Remembering the parts of the court. So.
Yep. All right. And we'll cut that one there. And we'll go into the next one. Now, this one, I don't have my name up here yet. I haven't filled that out. But this is the second document. Now, this is my own way I put this together here, so it may not be as proper in accordance with these guys over here. So I'm still learning this stuff here, but I'm getting there. All right, so we'll mark brief and memorandum in support of motion to dismiss. This is the brief, your memorandum, your points of authority that gives support to your motion. So same thing comes now, for 5% of sewer jurors submits the brief memorandum, points of authority in support of the motion to dismiss with additional documents and support incorporated herein. Basic argument, telling the people, telling them what my argument is. Hey, parental rights are unalienable rights. Those kind of rights come from the law of nature declared in the Declaration of Independence, blah, 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 blah. Kind of make your just real short argument there that, hey, this stuff isn't supposed to be happening. Statement of jurisdiction. This is a good one. Lack of personal jurisdiction. This process has no standing in law inside the borders of a state. Article 1 admiralty courts and tribunals are limited in their jurisdiction pursuant to, and this is me, this is my paperwork attacking the emergency or ex parte protection order based off of a United States code that's from 1994 that in 2000 it was found to be unconstitutional to do this process. So here's all the code regarding all that stuff, how it's lack of personal jurisdiction. And so when the other side gets this, they have to go through this and try and give rebuttal to this stuff, and they have to prove their standing in law. All of them, every single one of these right here, every single one of these grounds, if they can't prove one of those, they're done. So it only takes one little part of jurisdiction that they don't have. So you guys can kind of see along what's going on in here. And then here comes the points of authority. I've quoted from annotated constitution because I'm talking about the like the maritime law. Here it is in the admiralty jurisdiction. Congress may implement the admiralty and maritime jurisdiction conferred upon the federal courts by revising and amending the maritime law that exists at the time the Constitution was adopted, but in so doing, it cannot go beyond the reach of that jurisdiction. Okay, that's from page 16, or no, that's reference footnote 1681, which is down here. Okay, this power cannot be delegated to the states. Hence, acts of Congress that purported to make state workmen's compensation laws applicable to maritime cases were held unconstitutional. 1682, that's this one here, Knickerbocker Ice Company versus Stewart. Okay, these are just straight up, you can't do that. And you're going to have an awfully hard time proving you can't get past this. I mean, literally, you can't. So again, I don't care what they say and what they respond to. And you're going to love this next one here, John. This is where I got into the law of nations. The legislative power, basically you're limited, dude. You cannot change the fundamental law. That's points of authority. Okay. And then I slam him with this right here. It's a capital offense to do that. So kind of letting them know that that's a little bit on the unlawful side there, guys. Can't be doing that's a capital offense if you subvert the law. Mess around with the fundamental law in any way, shape, or form. You act under color of law, legislative branch, or anyone else, because you're deemed to know the law.
That's an interesting question. You brought up an interesting point there. When you talk about the fundamental law or the common law, you also have to remember that if you're going to bring up such a point, you need to be prepared for the question, well, what common law are you talking about? And those are not statutes, codes, rules, and regulations. That's the stuff that governs them, not us. So when you talk about what actual fundamental law was trespassed, pull up the big book again here.
Well, in my brief here, it's right there in the very beginning. It's in my argument. For
you
me,
use Lex
parental rights
Scribonia.
are unalienable rights, those kind of rights, from the Declaration of Independence, so that no man or set of men government can take them away or create bills of attainers that would fundamentally alter our form of due process of law. And among these rights are life, liberty, and pursuit of happiness. This is why we, where the SCOTUS has ruled hundreds of times, the parental rights are fundamental liberty interest. It's the fundamental law, the one the legislative branch has no authority to codify or codify. Here's the Constitution of the state of Idaho.
Even over and above that, when you talk about the Constitution as the contract, right, under the articles thereof, we go back to the question of what is the law? And that question under Lex Scribonia is, which is Latin again, goes back to Roman law. It's a law of the late Republic abolishing the acquisition of predial servitudes through prescription. Now, if you don't understand what that means is, for example, the current mechanism through Title IV, okay? In my particular case, I went through and did what's called a compartmentalized audit. And I found out that for every $1,000 that I was paying, the state was taking 800 of it. Well, that is an acquisition through, that's an acquisition of predial servitudes through prescription. In other words, they use statutes, codes, rules, and regulations to do that. That's a trespass of that law. And so that's why I said when it came time to actually researching what law you're talking about, know and understand that law itself is, you talk about the common law, that's the stuff you find in your big books. And, it's not like your stare decisis, which is examples of cases that attorneys walked into the federal court and said, hey, can I do this? And usually the federal court says no. So basically, because these things have piled on top of each other, and that's where the constructive fraud comes from, right? They took this and they said, we're going to do this in good faith. And they piled this thing on top of it with the same, and it was this constant adding a layer and a layer and a layer and a layer. And next thing you know, by the time you get down through all the layers, your kids have aged out, and now you've got this big bill. And I just, doing what I do, I said, well, I can cut through layers a lot faster with a knife than I can peeling them apart one layer at a time. And I just did what I do and effectively did that. So again, that's just for reference purposes. If you want to go back and watch this later, that's an example of what law was broken. So
is that a cut?
That's what I would call it.
Okay, so
No.
just a little critique on that. When we go into a new section like that, you were awesome at the first, and then we drug out. And I would just say, go into it and say, here's the meat of it, and then at that point say, now we're going to talk a little bit about it. You guys can get some more knowledge about this if you want, but now you've got everything that you need to know about how to do this motion to dismiss and why it's important. Can I run into a couple and kind of give you guys an idea of what I'm talking about?
Have at it, brother.
Okay.
Yeah, I was going to try and blow through this all at once without any interruptions so that we got through the document, and then we can talk about the document. So I think what I'm actually going to probably do is
it just got
on my own without any interruptions, and then I'll just put those out exactly that way. That way there's no interruptions. In the background or with you guys. Go ahead, John.
Okay, let me, Ted, are you there? You ready to start another one? You're good? Okay. Let me just get a couple documents ready here. I'm going to share my screen.
I do need to add there for some of those is in Idaho, we have to do a notice of hearing, and it's kind of like just
a brother.
It's just what's that?
That's exactly what I was going to run into.
Perfect.
Okay, so let me share my screen here. Okay, you guys got my screen? You can see me, Ted? Okay, all right, Ted, go ahead and mark. Okay, you guys, so.
Make sure you full screen which document you're looking at.
Okay, I'm gonna start over again. What'd you say, Kirk?
Make sure you full screen whichever document that you want to look at.
I will when I get in there. Or I'll put it up. Let's see. Okay. All right, Ted, let's start that again. Ready, Mark? Okay, Kirk and Chris have been talking about doing notice of appearance and motion to dismiss and some other videos. You guys need to check those videos out. Critically important documents to get up front. Once you get going in the case and you start filing motions, and this is also going to go in your motion to dismiss, you always got to do a notice of hearing. So when you do that motion to dismiss or any other document that you're going to file, I usually throw mine in above the certificate of service, and I say, this hearing is set to be heard on this date and this time. This is really important to include in all of your documents. Lets everybody know where to be and when. How to set up a court date. So if you've got opposing counsel has filed a complaint against you and you've been required to appear in court, you know that there's already time set aside for you guys. So you call the clerk's office and say, hey, I want to get this other motion to dismiss or this other document before the court. Do I have time for that? And I'd like to reserve time in the court. Or alternatively, if you're the initiating party and you want to have a motion heard of yours, you call the clerk's office up and say, hey, I need 3 dates to have my motion heard. Give me the next 3 dates. And or you can tell them, I want it a month from today or whatever date you want, and say, give me 3 dates. They'll give you those 3 dates. You send those dates in an email to opposing counsel. Say, hey, these 3 dates are available. Which one works for you? Opposing counsel will get back. They'll choose one of the dates. And so then in your motion, so here I've got a motion to return escrowed attorney fees. And I said, this hearing is set to be heard on this day and this time. So you'll include that in the document. You will also file, and this is really important, to do a notice of hearing. So it's just a super simple document, your title of your document, the court, the parties, and then you just say, here I come, add in all the stuff that go watch that notice of appearance and add in there, seri juris and persona and all, you're standing in the court, and then put in, say, here's I notice a hearing, and then send a copy. And this is so critical. I got into court one day and they said, you didn't file a notice of hearing. And I said, yes, I did file a notice of hearing. And I have a copy of it right here. So take it with you, because that's one of the tricks they do is they'll say, well, you didn't file a notice of hearing. And they say, yeah, I did. And I got a copy of it and it's file stamped and everybody got a copy of it and everybody knows that they should be here. So let's hear this thing and get it done. All right, ready, cut. Do I got to do that again? Oh, shit. Okay, tell me when you're ready, Ted, and I'll run it again. Okay. All right, ready, Mark. Okay, guys, Kirk and Chris gave you some really great information. Another video, notice of appearance, motion to dismiss. Go check those videos out. One thing that's critically important, every document you file is to put in a notice of hearing. So here I've got a motion to return attorney fees. And at the bottom of the document, I have it included in the caption above the certificate of service. And I say, this hearing is set to be heard on this date at this time. So that lets all the parties know, what date they got to be there and what time is the hearing. This is critically important to include this in every document that you file with the court. Now, if there is already a hearing set, so they filed a complaint against you and you're filing your notice of appearance, you can call the clerk's office and say, hey, I want to get this motion to dismiss in. We got enough time for that. I want to have this heard together on the same day. And they'll get that scheduled on the docket. And so they'll specifically say, yeah, this is set to be heard on this day. We're going to put it on the docket the same time that their complaint is heard. Your motion to dismiss is going to be heard and you're going to be docketed. And so then when you confirm that with the clerk's office, that your notice of appearance and your motion to dismiss are on the docket, then when you file those, you put in this little caption, hearing is set to be heard on this day at this time. Now, if you're the initiating party and you want to file a document and you want to be heard before the court, so you'll file your motion. So again, in this case, I've got a motion to return escrowed attorney fees and then above my certificate of service. So now how do you get these date and times? Call the clerk's office and say, hey, I have this motion. I want to be heard. Give me 3 dates. And I would like these as soon as possible, or you can put it out a month, whatever you're comfortable with to prepare for the hearing. Maybe you need to get discovery or something. You want to give yourself more time for that. You call the clerk's office, get 3 dates. Send those dates to opposing counsel. Say which one of these dates works for you. They'll hopefully respond to you. If they don't, we'll do a motion to compel in another video. But typically the attorneys will respond and say, this date is good for me. Or they may say, none of these dates work for me. Then you go back and call the clerk's office and say, give me 3 more dates. And hopefully you'll kind of coordinate that with opposing counsel. So then whatever your motion is, you're going to put that in there. Now, if you're the initiating party, you need to do a notice of hearing. Simple document, the court, the parties, the case, and then just a real quick title, notice of hearing. And then you say, now comes plaintiff. Now here, go back and watch the notice of appearance. I wasn't educated in the law at the time, but I should have put in here, Surrey juris in persona and all the stuff that Chris talked about in the notice of appearance. So go back and watch that video, notice of appearance, and identify your standing in every document. And so you'll file that notice of hearing after you coordinate everything with the clerk's office and with the opposing counsel, get your notice of hearing in, get a copy of this thing file stamped, take it with you to court. One of the tricks they try to use with me, oh, you're not on the docket today, Mr. Gentry. You didn't file a notice of hearing. Well, yeah, I did. And here's a copy of it, Your Honor, file stamped. And here's a copy of an email with the notice of hearing attached to it sent to opposing counsel. So yes, Your Honor, we were scheduled to be here today. So that's it on notice of hearing, guys. Thanks, and cut.
Okay. Now I want to add something here. In Idaho, the way they do it is the notice of hearing is essentially blank. And what they do is they fill out the notice of hearing with the court date, and then they make copies of that.
Hey, Kirk. Ted, let's get a mark on this and let's cut this into the same video. So right where I said thanks, then switch it over to Kirk. And then Kirk just kind of preamble that and say, check your local jurisdiction in your state, that there's different rules. For example, here's what's going on in Idaho. So give him a mark, Kirk, and do that again.
All right, Mark. Now, some jurisdictions are different than what John was just explaining. And we have to do in Idaho. So you want to check your rules of procedure and what you want to do, and what documents you all have to file together. So in Idaho, we have to file a blank notice of hearing and a blank order. So you have, in my case, would be the notice of special appearance. That's just an initial document when we're talking about this kind of stuff. The motion to dismiss, okay, that goes along with the notice of appearance. And then the notice of hearing, so that the court can fill it out and send that out. And then a blank order. You know, that's all going to be in your relief that you're seeking in your motion for dismissal, which I didn't get to there. But so we'll mark that right there.
Okay, good. Love it. That was really good too. To the point. Loved it, Kirk.
So another mark I'd like to add right here. In addition to this stuff, checking with your jurisdiction and how things work, when you file, when in Idaho, when I file my affirmative defenses and counterclaims, okay, that automatically, they send out a court date. Okay, that's already there. We have a court date set. Now, if you're the moving party, you have to do, in Idaho, you have to do a summons and the petition. Then that gives them whatever, per the rules, will tell them how many days they have to respond. In Idaho, it's usually it's 21 days to respond. And so that's the flip side of being the moving party, is now they have 21 days to respond to your petition, do their affirmative defenses, do their notice of appearance, whatever they're going to do, hire an attorney. You know, they hire an attorney to respond to your petition. Well, yeah, that attorney is going to admit the jurisdiction and you got them. So if you're the moving party, and then the order, you know, that comes all together as a package deal. So we'll mark that one there, and that can be like added to the beginning of where, to John's, where he's talking about being the moving party in your own petition.
That was interesting. Ed said I ran kind of fast through that. Maybe I should slow down a little bit, you know, trying to get in there, but you know, you guys can always rewind these videos.
Right.
Yeah, I think with these videos to engage people, it needs to be concise and informative and interesting, you know, in a short window, because you can only hold people's attention, you know, for just a short few minutes.
Right, short and sweet as we can. Mm-hmm. And then what we could do too is, after the mark there, like certain things that Chris was wanting to talk about, you know, we could do a special mark there, just like what we just did there, for 20-30 seconds of something that you can clip that and add it to it, instead of trying to put it all in at once. Mm-hmm. Nice. Trial and error.
Yeah, and we can come back and reshoot these things later on,
Oh, yeah.
And fine tune these things, and we can remake the same material better later on,
Yeah. So this document here is what we were kind of just talking about there. Is this is a response, okay? Response to a petition. So this one happens to be for the protection order with the response, affirmative defenses, with child and counterclaims. That's right, counterclaims. I have my own claims to make here. Basic, this section right here, the very first section, is pretty much standardized for first thing that you've got to put in there. Again, comes now, who you are, here and after referred to as respondent or father. You're telling them who you are in this particular document before them, who you are. So that's that raising the hands thing. So in some of these petitions and stuff, the very first thing is, you'll have to give whether you admit or deny the allegations. Because if you admit the allegations, it's done, right? I mean, there's no need to really go to court. We need to do a summary proceeding. You show up and it's the order's granted. But if you're gonna, if there's any objections to any of their claims, that right to a cause of action there, that standing, they're making false claims, okay? And then for me, what I put in there was respondent denies all allegations of the petition pursuant to, again, this has a rule that says I can deny everything and require you strict proof of the claims, okay? And then you go into affirmative defenses, which, based on their claims, again, this almost is part of motion for dismissal, but this is actually a response. Okay, so number 2, petitioner fails to state a claim for which relief can be granted. It should take nothing thereby, and her petition should be dismissed pursuant to Idaho Rule of Civil Procedure 8C. So here's one: assumption of risk, under duress, estoppel, fraud. Imagine that, unsubstantiated claims. Respondent reserves the right to amend affirmative defenses, counterclaims, and demand for relief, to make oral arguments, oral motions, submit documents to support oral motions later, present exhibits and other forms of admissible evidence to be used to rebut the claims of the petitioner. This is just an initial response, but this tells the court that I'm still holding on to some of my rights here. This all depends on what happens with their response to my response and my counterclaims. Because now they have a certain amount of time, usually in Idaho, it's 7 days to respond. Or no, it might be 21 days for them. But yeah, because I have counterclaims. If it didn't have counterclaims, it'd be 7. I believe it's 7 days in Idaho. So this is the counterclaim. Again, this may be part of the same document, but again, you have to do the comes now, blah, 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 blah. So in the counterclaim, what I'm doing is I go through each and every one of her claims. And this is actually the very beginning part where I talk about the establishing the jurisdiction. This is part of those 7 elements of jurisdiction. Who are we talking about? Here's the parties. Who are they? Oh, the minor child. Okay, we got a minor child here. Okay. Oh, are there any other court cases? Yep, sure is. There's one right here in fraud. I even put it in fraud just to re-emphasize that this case is all by fraud. Other proceedings, are there other proceedings pending? Okay, yeah, there's pending complaints with Garden City Police, Boise Prosecutor's Office, and E-Clause yet to be filed. So I'll let them know we're working on stuff over here in the background while we're responding to this, which goes right back to why I'm reserving these rights up here. And then once you get through those, and this is pretty standardized response, okay? So once you get into the meat of it, then you get into the statements, okay? If you're going to give, this is giving rebuttal, okay? This is rebuttal, what you're giving here based on their claims or statements, okay? So you kind of quote which statement you're talking about, and then is false. In fact, and then you make your statements. I have to make my statements here. In fact, no such occurrence happened. So this goes back to that strict proof that I'm going to require, and which is that new thing that I found recently is got to put them on notice. We want them strict compliance with the rules of evidence. That hammers them hard because now there's no more hearsay. And in mine here, I include, this is under penalty of perjury. This one statement that I'm claiming that is false and that she is going to have to prove, which she didn't. Perjury is punishable here. That's Idaho Code. Okay, Idaho Code section, Title 18, 5409, subsection 5409. Punishment for perjury is punishment imprisonment in the state of prison not less than 1 or more than 14. That's a felony. Perjury is a big time felony. Okay, that's $250,000 damages. Fine. Title 18, United States Code 1671. And then all of these right here.
1621, and if it's subordinated by the court, it's 1622. So you got the double whammy in there, right?
Right. Okay. Yeah, 1621 for the damages, the fines. Felony, that's a felony, so it's automatically up to a $250,000 fine or damages per instance. Now I've got 26 counts of perjury here, just in her initial petition. And actually I got about 20 right here listed out. But each and every statement that you made in there, you have to give rebuttal, and this is the way you give rebuttal here. And each one of these is itemized, okay? Now, I started a new section kind of basically here because she had a written statement. And I made sure that I put it in there, received with the petition, presumably under penalty of perjury, because it's a written statement that's attached to the petition, but it's after the petition. And in reading the rules of procedure, technically that written statement is not admissible if you go under strict. So there's ways to get rid of those little statements that they like to just throw in there. And you know, I tore them up pretty bad in court. I'm just going to keep going here and I'll talk about it in a minute. But all of this is just get down to the bottom here, okay? What you're seeking, your relief, the relief that you're seeking. Where is that? Maybe that was it. Oh, no, right here. Here's a good one. Cure provisions. They may protect themselves from further criminal and civil exposure by refunding the emoluments they have swindled from their client. They may also like to recuse and take his liability insurance with him. If he chooses to stay, please provide the name of your insurance carrier, policy number, and policy limits, and all billing records of the client during the time representing the mother. Seattle Rule Civil Procedure 4.13 and Rule 1.2D and Rule 0.10. Oh, that's Idaho Rules of Professional Code of Conduct. So this is where I'm nailing them. 4.1, Section 3 is an attorney can't represent a client who's committing crimes. I brought that up. And then Rule 1.2D is fraud. So this is fraud upon the court is the crime under 1.2D for Idaho Rules of Professional Code of Conduct. Okay. Then I declare under penalty of perjury pursuant to the law of the state of Idaho, foregoing is true and correct to the best of my knowledge. Here's the demand for relief. And your prayer is you're praying that the court will move in your favor and grant your generic order that you have there. It's blank. Okay. For relief set forth in the response and counterclaims above. For such other and further relief be granted respondent father as may be just. Well, I can go in here and claim which is where we start getting into cross claims. And all of these, it's a $250,000 fine, damages. You itemize those, count 1, count 2, count 3, count 4, count 5. You know, itemize each one of those counts of perjury, and you're claiming in the end, you know, in the end, you're claiming the damages.
Get your clicker out.
Get your clicker out. This is the way that it's supposed to be done, but these attorneys, they don't do this particular part. Now, in the recent one that I just received, they've got some counts in there, but they're not asking for any damages. Sucks to be you. They don't want to play that game, play it that way. That's fine, but I am. I'm going to play it that way because that way it's proper before the court. We'll go ahead and mark that. So that is proper before the court, that you're claiming your damages right now. This goes back to that in personam. I'm appearing specially here, objecting to the personal jurisdiction, to all jurisdiction, okay? And I am now the moving party because all of your claims are false, and in fact, that's a felony. In fact, that's a felony. In fact, that's a felony. Count 1, count 2, count 3, all of those listed up individually. Count 1, count 2 is a felony, okay? And then you list over here, all in one, how much you owe in damages. So that's that one. That's in response to a petition. Your affirmative defenses, counterclaims, and the cross claims would be the actual part where you go for the damages.
Ted, how would you, or Kirk, how would you tag that video for Ted?
I would call that
keywords that people are searching for.
Call that a response to a petition.
You get that, Ted? Okay.
I sent you that email, Kirk, that blank motion for foreign sport order with the stare decisis we talked about on the phone earlier. You said send it in Word, so I did.
Hey, can I do one on motions and memorandums? This would be some really good info.
Yeah. While you're doing that, hey, Kirk, pull up that email.
I'm going to.
Remember, because the next one we're going to do, I want to talk about this, because I'll read it along with you.
Ted, you ready?
Would that be the motion to vacate one?
Yep.
Okay, I have that on there.
Okay.
Ted, so I'm gonna go share screen here.
Oh, you jerk.
Are you ready to start? Tell me when you're ready.
Go ahead.
Are you good, Ted? I can't hear you. Are you good to go? Give me a thumbs up. Yeah, I'm on PC.
No, he's using Adobe Acrobat Pro.
Well, man, I'm going to switch to a Word document. All right, let me see if I can find that document real quick in Word.
Also, too, any documents that I share are also already uploaded into my group, just so you guys know.
All right, this isn't this is okay. So this isn't the actual motion that goes along, um, but I'll work with it. It'll big thing. Okay, and you can see that one. Okay, how's that? You want me to come down a little bit? So is that all right? This look good or bigger or smaller? Okay. How's that? How's that? All right. I haven't looked at this document in a long time. Okay. Yeah, I'm just going over structure here. So content doesn't matter. Okay, are you ready? Tags on this video, motions and memorandums of law. Yeah, that'll work.
You start doing this too long, you start using the F word like a comma.
All right, you ready to go? Good.
Mm-hmm.
Good. You ready to go?
Guilty.
Okay, ready, Mark. Okay, guys, this is just a really quick overview on structure of writing a motion, how to get something that you want from the court, and then a supporting memorandum of law. And I love the way that Kirk put this. When you file a motion, it's like raising your hand and saying, I want to be heard. And so you'll make a statement. This was some of my earlier work while I was still learning. But what I would put in here is my first sentence is I would say, pursuant to Tennessee rules of civil procedure or whatever state you're in, I'm bringing this motion before the court. Typical header that goes on every legal document, the title of your document, a brief statement about what you want the court to do, and then again that raising your hand and saying, pursuant to this rule, and then you'll go through some facts about what happened and why you want something to happen. And then your prayer for relief, wherefore, based on these facts, I want this to happen. I want this money returned to me, or I want the court to stop doing this, or I want the opposing party to stop or start doing something. And then do your signature on here. I always in Tennessee. It's appropriate to advise the parties of when that matter is set to be heard. Go check out our other video on our Kirk's Law Corner YouTube channel on a notice of hearing, and check out that video on how to do a notice of hearing, and then your typical certificate of service that goes along with it. Now, when you file a motion and you're representing yourself, the courts are very, I almost say, antagonistic toward us. And so they will do everything to not allow us to be heard. So how I get heard is I file a memorandum supporting my motion. And in that memorandum, I will include evidence and facts and parts of the record. And so, instead of me going into court and they're saying, no, you can't enter that evidence, or we don't want to hear your arguments, or you don't know the law. Instead, you just put all that stuff in your memorandum of law and you get that sucker file stamp. And I'll tell you, that saved me so many times in appellate court because I got this stuff. Another big part about doing the memorandum of law, as non-legal professionals, we forget things. And so we forget to bring up a point in court, but you can make those points and you can present your evidence through a memorandum of law. So let me switch over to doing a memorandum of law. So, same thing with your header, same thing with your title. And you might throw in here memorandum of law supporting my motion to whatever. And then I throw in a section on background and facts. And I love citing the transcript. You guys always get your transcripts, cite that. It's part of the record. So I love, and you'll see here, I say, March 10 transcript, page 204. Notice I have an exhibit attached here, and this is where you enter your evidence. So I don't remember what it's about, and I won't go into it, but you'll see this thing littered with exhibits that I'm attaching to my memorandum of law to support the facts that I'm establishing for the court. And so you'll see that again, littered throughout the document. And then I'll get down into my arguments, and that's where you state the law to the court. And so, I say it here in my argument section, in Fox v. Fox, it was established over 100 years ago about whatever I was arguing in this case. And I'll go through. And I encourage you guys, we're going to do another video on how to do legal research in your case. So check out our video on legal research, and you're going to love how we go out and research and find these cases. Most of my stuff is Tennessee or federal law, but we're going to show you guys how to research it in any case. So you'll see I have this thing just stuffed packed with the law so that they can't deny what I want. I'm just saying, here's the facts, here's the law, here's my evidence. Please do what you're supposed to do. And how do they fight that? And I go in after I do that law. I might go in and throw some more evidence and attach some exhibits saying, well, here's what the law says. Here's more facts and more evidence supporting what I want. And then a conclusion. End your memorandum of law and say, this is what you guys need to do. Give it back to me. Fix it. And I hope you guys take this knowledge with you, file your motions, ask the court for what you want, raise your hand, say pursuant to this rule, attach a memorandum of law to it. It strengthens your motions so much, and it allows you to do your homework and get the information you want in front of the court, even when they say, you don't know the law, you're not in here, you can't enter that evidence, and they come up with some bullcrap rule why you can't enter your evidence. Which is typically very commonly in violation of the rules of evidence for that jurisdiction. Get it into your motion, get it into your memorandum, guys, and cut.
Yeah. So with what, like here, this is a memorandum. This is in support of your motions, whatever motions you're making: motion to vacate, motion to dismiss, motion to return attorney fees. This is just a memorandum. It just supports your argument. Okay. So your brief is the part of a brief synopsis of what's before the court. Okay. More or less, it's for the judge to sit there and follow along as you're making your argument orally.
Yeah, that particular memorandum of law saved me $188,000 being extorted from me under color of law. So
nice.
They work.
So, yeah.
Even when
that administrative duties, guys. This is the administrative duties. So, if we can get this stuff filed, let me see if this motion to vacate one is. It's not. I copied and pasted your stuff into mine. Let me see. I know that I have yours too.
I just sent you a new version of it, Kirk, just so it'd be easier for you to find it.
Oh, I have a special file for you. I know I do.
That's scary. I have a special file.
And it's not file 13. Motion to vacate orders blank. Here it is.
That's the little rascal.
No, your stuff, I'm starting to, you know, pop that stuff open and copy and pasting stuff out of it. So
that's why I put that stuff out there, so you guys can do just that.
And this is perfect right here, because this is kind of what I actually wanted to bring up with stuff like this. It's blank, but I have a bunch of blank stuff, but I think it was better to show what I already have done to show to keep it short.
Pick that up on the screen real quick so everybody can see what it is.
I'm working
this particular document is posted in the group.
Now this one is PDF, so let's see what it does for you.
I sent you the Word version as well in the email.
Oh, that's right. Does this mess you up over there, Ted? No lo comprende. No la cabeza. I am going to let me find the word.
Yeah. Right.
Yeah. Okay. Well, this is going back into the PDF because I can't immediately find the word.
Collapse your side menu on the right. That little black arrow right by your mouse. Yeah. Ted, is this working okay for you, buddy? I mean, you're the one, you got way more work to do on this stuff than we do talking, man.
Right.
So we want to make it as easy for you as we can. So, you know, tell them.
Yeah, Brenda's kicking butt. Right.
Is that like the manual release with the massage parlor?
Yeah.
I said, is that like the manual release at the massage parlor?
Right.
Right.
Oh.
Okay, so we're gonna do this motion to vacate.
Okay, this one I conceived based on a federal decision that I'd gotten in my case, when basically the federal court came out and said that they can't cross state lines to do what they're doing. That was basically the challenge. And the through the orders, the court did support that assessment. So, this goes back to when you ask the court a question, just because you don't get a verdict in your favor. For example, yes, we are granting you $10 million. Have a nice day. That doesn't necessarily mean that you lost. They can dismiss your case and grant you your remedy at the same time. You just have to learn how to read the orders. So based on the order that I got, which I did attach to this when I submitted it to the lower court, I went in. It's very, very short. It's a very, very short thing. Matter of fact, I spent more on these standards of review or stare decisis than I did on the actual language of the motion. So it was very shit. This is one of those things that less is more, right? Remember, the person to whom you're filing the document with is probably pretty busy. So if you can make it short and sweet for them, you just made their day, right? So because I was able to construct this in the way that I did, scroll down to page 2, Kirk, the standards of review section.
Okay, so this is just a standardized form again,
Yeah, this is one I created.
This is it's whatever it looks like in your state, whatever court that you're doing. This stuff here is all based on whatever it looks like in your state, and you can look at your own paperwork and know exactly how that header is supposed to be. So, motion to vacate the foreign support order. So he's making a motion to vacate, and he's claiming which one it is that he's wanting to vacate. Here comes before this court. Pro per basic standard stuff, manufacturer creation of fictitious obligation. This is short and sweet. The False Claims Act. We talked about that one today, right?
Yeah.
Certificate of service. And then here's his standards of review.
So basically, like John just pointed out in the previous video with the memorandum of law, I didn't need to go into all of that because all that stuff was already on the record in this case. So all I needed to do was file standards of review that supported the motion. So, and many of these, come to find out, are also relevant to many of you. So, as it turns out, like for example, this Miller versus U.S. Kirk talks about that all the time. Davis v. Wexler, the assertion of federal rights when plainly and reasonably made is not to be defeated under the name of local practice. Well, this is key because remember, you're more than likely, even as pro se, you're going up against a practicing attorney, right? So if you can help the judge in any way with supporting stare decisis that removes possible, pain in the, action or negative response from the attorney or wherever, the court can say, well, yeah, of course I'm going to do that. And he gave good standards of review and supporting case precedent to establish that, right? So whoever your attorney is from Dewey, Cheatham, and Howe, don't take it personal because there's stare decisis that supports the argument. And, we got pro se pleadings, assistance of counsel when we're talking about administrative proceedings, right? Well, because every one of these proceedings is administrative in nature. The Sperry versus State of Florida, the X-ray, the Florida bar, that next one there, where proceedings are administrative in nature, non-lawyers are authorized to provide representation.
I love that. I'm going to hammer with that one.
Yeah. Why is this important, right? Because when you go in and you start working with each other, you can say, hey, look, there's a bar to prosecution here, right? Mm-hmm. I'm here to bear witness. And yes, I do have expertise in some piece of subject matter that's relevant to this case. Are we here to talk about it? Who knows? That's why I'm here. So if we get into it, I'm here. for convenience.
I did that to a group of a couple of prosecutors and some proteges that were in the court there,
Certainly.
court watchers.
Mm-hmm.
And they ended up asking the bailiff to have me stop talking to him because I did that, barred a prosecution, and here it is.
Right.
Right in the middle of a criminal trial.
Mm-hmm.
Didn't like it.
Well, you know, it is what it is. See, this is what it looks like when we fight back against the swamp, right? Mm-hmm. In other words, people like me, I don't care. They can't touch me. That's for darn sure. I've got special dispensation, and we've been through that. So here's another one from 1990, Howlett v. Rose, right? Mm-hmm. Federal law and Supreme Court cases do apply in state court cases, right? So, for example, if you walk in and you've got the Hardwick versus Vreeken case, they're going to say, inevitably, you're going to hear some idiot say, well, that's out of California in the Ninth Circuit, if they've even heard of it. Well, here, the supporting documentation that allows that stare decisis to be heard in your case, this is where we take their layers, stack a few of our own, and beat them to death with it. This is an example of how to do that. So how you get your standards of review like that to be admitted into your case is you can say, you know, hey, look, I've got supporting stare decisis that says federal law and state court cases do apply here. Here it is from 1990. So another one, the next one down, one of my personal favorites, Owen versus City of Independence from 1980. Basically, they can't claim anybody acting under the color of authority or color of law or whatever. Basically, anybody in government who receives an emolument cannot claim good faith when they know they're violating constitutional or federal law. So, you know, there's no immunity there. So that said, there's a difference between no immunity, liability, and prosecution, right? There's different thresholds, there's different tiers.
Well, the most common term we're referring to here is, well, we had good faith reliance, Your Honor. We had good faith reliance.
Well, again, when you can go in and show through stare decisis, in other words, these standards of review, we talked about this earlier, that one guidance document that they claim good faith and reliance on. You found the case that particular code or statute was deemed unconstitutional. That takes and voids that entire guidance document. So when we talk about the use of guidance documents and good faith reliance in those, if you pick up a document and you go down through it like Kirk did and say, oh yeah, well here there's they're claiming good faith reliance in this code, this 18 USC 513C, and you go through and you find out that you do a search and you find out that was deemed unconstitutional, you can take everything from that document forward and thrash it because they can't claim good faith reliance, Owen versus City of Independence, on a document that is, basically been nullified through Supreme Court decision. So when we talk about the significance of a guidance document, that's where stare decisis plays a very key role. So that's one of the reasons why I did so much homework into this. And now that next one, Mayor versus Nebraska, this is from 1923. This one was a case where the fundamental right includes a fundamental constitutionally protected liberty interest in ongoing companionship in society with the child. And this includes protection of the relationship between the parent and child, even if the child is in state custody. So this one is relevant to a case that I'm working right now out of a different state. When we talk about, the foster system is state funded. That means state custody. So in reference to that one particular case, even if your child doesn't have to necessarily be in state custody, meaning in state jail or whatever, or in some kind of a group home or whatever. They could be, as long as that place that they're staying at is receiving any kind of funding, subsidy, and emolument. This case does protect, from 1923, does protect your right to maintain companionship, right? Because that's the word, companionship, and of course the relationship. So this one is going to be a key player in that one in particular case, which of course she might still be even watching. But then of course we go into the Hardwick versus Vreeken, and I spent so much time laughing at this at that point in time. I just had to put it out there, and come to find out that my local judge did get a giggle out of it. So
my judge didn't seem, the last one I was just in front of, he didn't seem to like it when I said no official with an IQ greater than room temperature in Alaska could claim that he or she could not lie. And that Ninth Circuit Court of Appeals says that that's a felony both in criminal and civil under Title 18, subsection 1621.
Yep.
You know what I had a question about this case. You know, if you scroll up and look at all of these other cases, they're all 1980 and earlier.
Sure.
So all of the Supreme Court opinions, it seems to me, that are enforcing the rights of the people are pre-1980. And most of the really good stuff is pre-1950.
Right.
Yes.
Where they,
1930 even.
Where they say we have a right to be heard, we have a right to confront adverse witness testimony, all of the basic elements of due process. Most of that case law comes from, or Supreme Court opinion comes from pre-1950. And there was a lot of stuff that happened around the 1980s, because that's when 42 USC 1983 was enacted, late 70s, early 80s. And so we had some good Supreme Court opinion coming out of it then, because they were trying to rein in all of this crap, you know, that was going on when 1983 was enacted. So this one, and this is a question I have for you guys. So this one came out in 2017. So who was the bad actor that pissed off another bad actor that they ruled on this thing? Or was this just the rare fair court that maybe still exists today?
Actually, it's actually Hardwick versus County of Orange and Vreeken. So Vreeken was the one that lied. And then the County of Orange, in their social workers and all that stuff, also lied.
Okay, so you had
the typical process that most everybody's aware of.
Who was the plaintiff?
Lying. But this is where this came from.
Who was the plaintiff in that case? Was he just a person?
No,
Hardwick.
Presley, the parents filed on behalf of the child, Presley Hardwick.
So
yeah, this is the child.
Parents filing on behalf of the children. Were they represented or pro se?
No, this is the child that filed this.
Yeah, I guess the parents
over 18.
but the child themselves did it.
Yep.
And they were represented by attorneys?
Yes, actually.
Yeah. Going through it right now and seeing if I can find the guy's name.
That one astounds me, that in today's world of the courts giving no justice against bad state actors, that they did in this case. And it just, you know, it's like, why? Because you don't see it anywhere else.
Right.
Well, this particular case is all really just based about, do social workers have the right to lie?
Right.
That's what this has been dubbed the right to lie case. So it really wasn't going technically after any particular people, but it was just more of a, hey, can we get some I watched the video of the hearing, and it's like, well, we don't have a clearly established that says that, you know, social workers can't lie. And the judge is just like, are you freaking kidding me? What do you mean it's not clear? Perjury is a crime, you know, both federal, criminal and civil, and federal and state, you know.
Right.
And this isn't what he said on the record. This was in his opinion part. So this is flat out. No official with an IQ greater than room temperature in Alaska could claim that he or she did not know that the conduct at the center of this case violated both state and federal law. Social workers in this case are alleged to have knowingly and maliciously violated the law in their attempt to sever Presley is the child, protected relationship with her mother. Perjury is a crime under federal and California state law and is the knowing submission of false evidence to a court.
See,
Both
this
crimes make no distinction between criminal and civil proceedings. This malicious criminal behavior is hardly conduct for which qualified immunity is either justified or appropriate. This is another one in conjunction with that Owen versus City of Independence.
Yep.
That just hammers them. It just, that good faith reliance right out the frickin' window.
Yeah, this case astounded me because perjury occurs so often and it is used as basis for decisions so often.
Yeah.
And even when you prove the perjury, they still base decisions on perjury, or if they change their decision, they still don't sanction or punish the perjury. So this case astounded me.
Right.
That the Ninth Circuit stepped up.
I know, right? Here's another thing. Go, I have this case. Pull this case file up, folks, and read it. There's a crap ton of good case law in there. There's lots of good stare decisis.
Yep.
I mean, we're also, at page 13 and 20.
I want to go to the decision. Let's talk about that decision real fast.
You know what? I actually have it right here.
When he talks about the conduct, okay? Now, when you talk about conduct, believe it or not, that type of conduct is also been adjudicated. And that case was Johnson versus Colonial Life and Accident Insurance Company, okay? And here's what they said. This came from 2005. Conduct is extreme and outrageous when it is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in civilized community.
Right.
Now,
I mean, that's just slamming them.
Oh, dude. I mean, that's just, that's like off the top rope, just bam, you know.
Right.
So when I talked about what type of conduct it would take to utilize, for example, the negative nexus, as far as the practitioners go in the courtroom, right? I said, well, look, we don't even have to discuss what kind of conduct and what's outrageous and intolerable. That's already been adjudicated. So, you know, in other words, it's all basically when you construct a document and you're constructing an argument, there are multiple things that you can either use to support your side and rebut their side at the exact same time. So it just depends on how much reading and research you've done into the actual process itself.
Okay, we're gonna wrap this up real quick, but I want to finish off. I pulled this Hardwick versus Rican up. See, County of Orange is the defendant, and Marcia Freakin, Elaine Wilkins, the estate of Helen, blah blah blah. So we get down in here, show you. I mean, this is kind of just right along with some of the paperwork that we were just showing you how to file. This is actually the opinion stuff. But if you pull that other part up, is right here, you know, here's the jurisdiction. We have jurisdiction over this timely and irregularly appeal pursuant to. You got to give them the jurisdiction. Here's the background. Okay. Tells you all about how what the background is on it.
Yep.
We get down in here. Look at that standard of review. So there's some of their cases that they've done. Oh, well, we have absolute immunity. No, you don't. The allegedly false statements and omissions made in defendants' court reports continuously submitted by them from February 17. This started back in 2000 through the termination of the dependency proceedings. So they terminated parental rights. Okay. Right here. The statements made by the defendant's social workers during an off-the-record discussion And during an on-the-record discussion that same day, where the social workers allegedly lied, but not while under oath, to the commissioner overseeing the dependency proceeding, triggering Presley's seizure. Legal abuse syndrome was actually causing her mental and issues, physiological issues. The alleged fabrication of evidence throughout the dependency proceedings and repeated suppression of exculpatory evidence in defendants' written court reports. Okay, you recognizing what these are right here? These are the claims. Defendants' corrupt recommendations that Presley continued to be detained, even though defendants allegedly knew they were lying to the court about the basis for the initial seizure and subsequent detention. Oh, maybe it wasn't seizure as in physical seizure. Seizure of the child. I thought she actually did have some sort of... Anyway. But then get down in here some more, like around that collateral estoppel. Okay, here's some case law. Okay. I want to get in right there at that. Here we go. Parents and children. This is pretty much it. Getting into close to that page 13. Parents and children have a well-elaborated constitutional right to live together without governmental interference. Right straight out of the Ninth Circuit Court of Appeals, one of the most liberal ones in the state or in the country here. That right is an essential liberty interest protected by the, I hate this, 14th Amendment guarantee that parents and children will not be separated by the site without due process of law, except in an emergency. Well, they try to construe it. We all know this, that they've been subjected to this. They try to always construe it as an emergency. Well, of course it's an emergency. Of course it's an emergency. He's got a bruise on his butt. And we got a Dr. Cox that over here looked at some pictures, and he's a child abuse expert, and he looked at a couple of pictures and says, well, yeah, he was hit with an object. Really? Hey, Captain Obvious. Obviously, if he's got bruises on his bottom, he was hit with something, right? But your conclusion looking at pictures is, oh, well, it doesn't mean that it was accidental. How do you know that? You're not a forensic pathologist. I don't understand how you can make that kind of, and you're a damn good forensic pathologist if you can look at a couple of pictures and say for certain that it, didn't happen by accident. Like, I don't know, fall off of his tricycle in my front driveway. Because he's 3. It happens. Over the years, Supreme Court has recognized this fundamental right. Here we go, that word fundamental. In many cases, for example, because if it's a fundamental right, it's not protected by the 14th Amendment. In fact, parental rights are actually protected by the 9th. Okay.
It's interesting in this case, and one of the things that I found critical when you talk about the 14th Amendment, why did they use collateral estoppel instead of, let's see here, estoppel by misrepresentation? Because if she lied, I mean, if the social worker lied, that would be an estoppel by misrepresentation, because that is an estoppel that arises when one makes false statement that induces another person to believe that something, and that results in that person's reasonable and detrimental reliance on the belief. That's exactly what that case was. So why the hell did they use collateral estoppel when they should?
They don't want to set it
by misrepresentation, right?
Yeah. They don't want to
because it was brought by an attorney. Right.
But this is what I said. This is what doing your homework does. So, yes, those things are true. But when you look at what a collateral estoppel is, that's a binding effect of a judgment as to matters actually litigated and determined in one later controversies between the parties involving a different claim from that which from that on which the original judgment was based. Well, the original judgment was based on a misrepresentation. So, you know, you got a chicken or the egg issue there. But that was just, you know, kind of my critique of a missed opportunity of where I think if the council would have used estoppel by misrepresentation, that case would have been litigated a lot faster and not gone how many years, right? 2000 to 2017 years. 17 years that case went. So, you know.
Well, I think she had to wait until she was 18, but right here, I mean, anyway, this just blows that 14th Amendment out of the water, because when was the 14th Amendment created?
Yeah.
1860, was it 1871? I think it was 1871. But here, listen.
Was it that?
Our decision established that the Constitution protects the sanctity of the family precisely because the institution of the family is deeply rooted in this nation's history and tradition. Oh my gosh, that sounds just like my statute, Title 32, Chapter 1010.
Right.
Word for word, because it is. Okay.
And go to the Mayor versus Nebraska. The exact,
because it's an unalienable right.
Right. So, you know, again, we can take that back to Mayor versus Nebraska, and they said even if the child was in custody, the companionship and the ongoing relationship is a fundamental protected liberty interest.
But then this is where they kind of bring it in here. Okay. The defendants do not contend, nor could they, that Presley did not have a constitutional due process right or a Fourth Amendment right protecting her against deliberate government use of perjured. Now, this was actually something that sounded like he said during the case, the judge, perjured testimony and fabricated evidence in the dependency court proceeding designed to rupture her familial relationship with her mother. This right is beyond debate. What they do claim is that the specific granular right to be free from deliberately fabricated evidence in civil child, see, this is crazy, civil child dependency proceedings. What do you mean civil child dependency proceedings? Where a parent's or child's protected familial liberty interest is at stake, had not yet been clearly established prior to the dependency proceeding at issue. No, right here. They can see that the rights Presley relies upon have been clearly established in criminal proceedings against parents, but not yet in civil proceeding context. We disagree. And that was where she was like, well, the attorney that was arguing for the social workers, we don't have anything clear, clearly established. Oh, right here, probably right here. See, clearly established. Okay. But yeah. This is pretty easy to find, folks.
Hit him with this particular one. Actus repugnans non potest in esse produci. In other words, a repugnant act cannot be brought into being, that is, cannot be made effectual. So in other words, I went in my eloquent way of the way I do it, said, what part of no don't you understand, dumbass? And because I just did it the way I do it, you know, that was like, they're like, you know what, we quit. Please don't hurt us, you know. And I said, okay, if you quit, I quit. Now, we're going to go back and answer the question of law when we get to that point. And that's where we are. So,
all right, folks.
My ass.
This is a wrap. We are done for the night.
Yep.
We appreciate you tuning in and hope that you folks learned a few things tonight.
Absolutely, guys. We love you guys. That's why we do this.
John dropped out. Yeah, John said he wanted to be done at 9. So
yeah, he had to get ready, get up, go to work in the morning. So anyway, that's why I said, you know, it's you know, when I get into these projects, I have no idea. Well, you know, how half of this crap's going to turn out. You know, some projects you expect they're going to be large, and they turn out to be, you know, a couple of weeks and you're in and out. This one, I said, a couple, 2-3 years. You know, here it is, 10 years later, and next thing I know, I'm sitting here live on the internet talking to how many people out there who are going to be listening to this or watching it over the course of time going, what the hell did I just get into? So.
Well, you can thank Randall Stone out there for me. I'd spent 3 hours on the phone with him.
Right.
And after I laid some of this stuff out, he's like, man, you break that down so Grandma can understand it. How would you like to have your own show? I'm like,
right.
Huh? So, a year and a half later, this is where I'm at, running to Ted. And I liked what Ted was doing out there with what his work was going on. And I'm like, I got to hook up with this guy. So I jumped on his stuff and put myself out there, and yeah, we get it off from there.
Yeah.
Right.
I know. Right. Right.
The days of
Way
our
outside
lives.
of this. Yeah. Well, also too, you got to bear in mind that there are a lot of people that are, number one, probably in the position they're in for very good reason. And number two, there are those of us out there who got sucked into this through no fault of our own. The problem with it is this practice, this repugnant practice, has constructed it in such a manner that you can't tell the difference. Right. Or you end up having to do a whole lot of vetting with somebody before you find out if they're true, if they're good, if they're bad, what the situation is. And it's one of the reasons I built that fund itself, because I knew that was going to be a problem. Yeah. Well,
you know, I've been around quite a different types of people, given my walk of life here. You know, being the child that was kidnapped by, you know, CPS in 1985. You know, I was the kid, so I've experienced that side, living on the streets, going through foster home to foster home. You know, several different foster homes, couple of group homes. I just kept running away. I mean, crap, even the couple of foster homes I was in, it was like they didn't care. But you know, Job Corps, Marine Corps, you know, jail. Yes, I've been to jail. Okay. And even my record will show I've been to prison. They not really prison, but it is a prison. But they retain jurisdiction. It was like what's funny. It's like they call it like a military style, and it's supposed to be about rehabilitation type stuff, you know. And I'm like,
right.
Man, this place is a freaking joke. You guys don't even know what military is like. But anyway, you know, I've met all kinds of different people, so I have a pretty good judge of character right from the get-go on most people. Sometimes when you're talking like social media and stuff, it takes a little while.
Right.
But there again, with being around so many different kinds of people, I've learned different mannerisms and how people talk and the way their body language is. I just have that sixth sense about people. So I'm not always right, and I don't always get, you know, that sixth sense, but there's definitely some key points in certain people that I pick up on real quick. So
yeah. Well, having spent my career
back to rule number one: unfriend, unfollow, and block, and move on. With that, John, you got anything you'd like to add to that? Thank you, brother, for your assistance here tonight. That was awesome. I think
thank you guys for watching. Keep coming back. You know, we're all learning here. I learn from these guys every night. I learn something new working with Kirk and Chris and Ted taking good care of us. So thank all you guys, and I hope you guys will come back and keep watching. And when Ted gets those little short clips, you know, share them around and help others learn how to protect themselves.
Yeah.
And I guess one last thing I want to add is my usual closing to don't forget to spread the love around, right? We got there's lots of people out there doing lots of great things. Tomorrow night, tune in Far From Normal, you know, with Jay, Bud, Peter, Jesse, and you know, they always have a special guest that really kind of get into nuts and bolts of like things like recovery type programs, people you can talk to kind of help get you through the psychological stuff. Me, Kirk, and John, we're more mechanical. We do the paperwork, right? So that's our strength. Also, Sundays and Thursdays, we got RFIR with Steve Ball and Brian Lee. Another couple of great people out there, just, you know, like many of us, caught up in this, just kind of doing just trying to find their little niche to do as much good as they can, and they do that. So Amelia Durant, I pop on with her under Portal to Justice every now and again. She's keep watching Portal to Justice. She'll do a show if something comes up. So you never know with Amelia. You gotta love Amelia.
And just one last note for the viewers out there is go to Kirk's Law Corner YouTube channel. Kirk, what's the name of that YouTube channel? Is it Kirk's Law Corner YouTube channel? Okay.
Yep.
So go on YouTube, search for Kirk's Law Corner, and subscribe to that. And that's the best way to get these little short clips and share them around with other people. So go on there and subscribe, and encourage other people to subscribe. Thank you all.
And those short clips and stuff, those will be per Ted Fogg. Thank you, brother, for your skills and ability and willing to work with us. None of us are getting paid to do this.
We're doing this for you guys, man. We're doing this for our kids. That's the reason we're here.
Brenda just asked me a little. Did I hear anything on my case? So I've got two cases. One is the same case. It's in the Sixth Circuit and the United States Supreme Court. And then I've got another case in the United States Supreme Court. After I did my talk in Georgia, the very next day, I was dismissed in the Sixth Circuit. They completely ignored my arguments like crickets, man. I mean, I asked big questions. Does a state get its sovereign immunity when it's no longer Republican? No answer, no argument, has no merit, nothing, just crickets. And so I filed a petition for rehearing en banc in that case, Brenda. And I'm waiting to hear back what the Sixth Circuit has to say. And I'll share it with you guys real quick. I showed this to the guys on here a little bit earlier. This is nine copies out of 43 that I have to do for the U.S. Supreme Court. So I'm just getting started on that. And these are not cut down yet. So these are 8.5 by 11. And I got to cut these things down into these booklets that are 6 1/8 by 9 1/4 inches. And the Supreme Court requires that these are printed on cardstock. So I got a busy time ahead of me these next couple of weeks getting these printed and bound up. So Brenda, that's what I'm doing.
And just because you don't see us doesn't mean that we're not here. Just so you guys know, we're always, whether we're involved in a project like John's doing, or like what I just dropped in on on Washington, got there today. The 14.8 pounds or whatever the hell it was worth of case follow-up reports. Come to find out, this is the information they've been begging for, and I just complied with the request. And they can't do anything if we don't report back to them. And when it comes down to it, I just take that extra step and I make those reports. And I don't mind doing it. I don't mind funding it. The same thing as John and Kirk and Ted. You know, it's because guess what? Whether anybody realizes it or not, by helping you guys, I am helping myself. So, you know, I look at it this way. I can stand there and I can go pay to argue in front of somebody who's going to treat all of us the same way they've treated all of us for how long. Or I can just say, hey, look, I'm going to go straight to the source. We're going to talk about what the law says, and we're going to go ahead and we're going to handle this, and we're going to handle it in a manner that is consistent with what the law says. And come to find out, all that we ever had to do was go ask. So knowing full well what the admiralty courts are going to end up like, well, you know, didn't have to be a rocket scientist to figure that out. So that's what I had to do, was just say, hey, you can't do this, you can't do that, you can't do that. They're like, you know what? Damn it, we're caught. Yeah. We're out of here. Well, that didn't mean that I quit. That just meant I'm getting warmed up.
No, Kirk is busting his ass. Chris is busting his ass. You know, my cases are, you know, I just want reform. That's all I'm after. I just want due process, you know, and that's all that Chris wants, and that's all that Kirk wants. You know, that's all we're here for. You know, my fight in the Supreme Court isn't about me. It's about restoring the rights that we are guaranteed in our Constitution. And, right. You know, Brenda made the comment, you got this. You know, I'm always thinking ahead with these guys. And the fact that what's going on in the state courts is due to the fact that the Supreme Court will not enforce the Constitution against bad actor judges. They just say, right. Oh, error in the circuit court, error in the district court, we don't care. We don't need to hear this case. And they deny certiorari. And so Brenda, I'm already working on my petition for rehearing in the Supreme Court. I anticipate that they're going to dismiss this case, fully expect it, don't care. I'm just gathering evidence, and I'm going to go back right before them, 25 days under Supreme Court rules. I'm going to file a petition for rehearing, and I'll lay out some more facts for them, and they can dismiss me again. I don't care. I'll keep pushing. I'll keep fighting, and I'll try to back them up against the wall.
Right.
Yep.
Also, too, just to let everybody know, I'm sure the cat's probably already out of the bag. In September, we've got an audience with some specific members in D.C. I'm sure you probably heard about that. The names of these people will be coming out soon.
Yeah, let's not give the date or anything like that.
Right. No, not yet, because we're still working on the planning of how we want to engage, and we want to make sure that these specific representatives, we don't want to just go in there and pound them with a problem they already know about. We want to go in there and with a viable solution that does exist in law, and we're also willing to show them that we're willing to do all the work. Don't have a problem with the work, but doing that anyway.
Just to let this cat a little out of the bag is we have 2 8-hour blocks.
So. Not sure about the exactness of that date, Ted.
But we don't.
Right, it's in September, but those dates don't sound familiar to me. Nope. But anyway, but as these details come out,
these are going to be in front of serious public officials.
Correct. I'm talking. I'll be in a suit and tie, the whole bit. So
I'll be in a suit and tie, clean shaved, butterballs, and ready to go.
I gotta shave again.
I got tired of shaving like every 3 days.
Right. So, but anyway. Mm-hmm.
Yeah.
Whoops.
Right. Yeah, this isn't a march. This is straight.
No, this is meetings. This is what we're doing this for. The right to redress your government. And as long as we did it consistently, we did it properly, and in compliance with the rules, which is what we've all done. They're like, yeah, we'll meet with you. It's no problem. And so it's a look, I'm not here to bust your chops. You got enough people busting your chops. I'm going to help you figure out a solution that's consistent with the law and American jurisprudence. So I've constructed a mechanism that we've been using for years and that works very well. It also works to deal with the corruption issue, and we use basically sectors that are already, because each state's divided into sectors. So it's big, 99.999% of it's already there. All we got to do is put it together and, kind of put the pieces together the right way, and we're done. And that's pretty much exactly what I did, is I took and put those pieces together that fit and that do the thing that they're supposed to do. So that's, and the thing they love about it is it's 100% real-time, accurate oversight. So if you got a bad actor, you pay somebody to do this job, whatever the job is, and they either don't do it or they do such a piss poor job of doing it. A kindergartner could have done better. You'll have a means of relief and remedy to do that. You'll have a process to follow, and it puts their feet to the fire. And guess what? Government, we don't have to petition the government, because guess what? We don't even have to ask the court, because we've already asked the court so many of these questions, and the court has said, no, they can't lie, they can't do good faith, blah, blah, and all that. So we can say, well, we can pretty much write guidance based on enough of this stare decisis that's consistent with law. Well, shit, yeah, we can handle that.
No. Well, somewhere in there ish.
Yeah, somewhere. So yeah, September 7th to the 15th or 14th or something. So I said I'm.
This isn't a march. We have.
Yeah. No, it's not a march. This is a meeting. Blocks. Yeah, this is a meeting.
Yeah, we're going to be in the Capitol.
Yeah.
In private. This isn't out on the streets.
Nope. Nope. Going in there to just talk to these guys. Mm-hmm. Mm-hmm. Well, this type of a meeting is what I've been working for. I mean, this is the reason that I started this project, because I knew where it ended up. You know, it started with an emolument, it ends with an emolument. I've said that. I've done it on the whiteboard how many times, and you know, it's just the nature of the beast. So,
and I was just recently asked, and I'm like, yeah, okay.
Mm-hmm.
I mean, I pretty much can't get much higher than where we're going to be going.
Right. And we're there where I'm doing it for you guys, specifically, Amber and Steven, and my oldest son. My oldest son has been waiting for this day for, let's just say, more than a few years. So, for him to finally get the answers that he's been waiting for, and that'll kind of help give him some closure too. And that's, you know.
But it's looking like I might come out there a week early.
Mm-hmm.
So I would be there during that 7th, 8th, and 9th.
Okay. Yeah, I'm gonna work on
get out there that early.
I might take a temporary 2-week apartment or something up there for a couple weeks. I'm not sure yet. I'm still working on all that. Huh? Yeah. Well, I would take an apartment just for the couple of weeks, because I could throw all the crap in my minivan and take it to the new apartment and set it up. And if I needed to make any packets or documents or whatever, I could do it right there in the apartment and save a bunch of time and a bunch of money, and make sure everything was exactly perfect, ready to hand to whoever's going to be in the meeting. So, and you know, I just go in and do the meeting with them. Mm-hmm.
Yeah.
Yes.
Yeah, I've been working on this project for a long time. Yep.
I put his name in the hat.
Love you, John.
Yeah. Just remember, this is going to be behind closed doors. This isn't a march, and this isn't out on the streets.
Right.
No.
Oh, I'm sure you'll be there with your banner and your with all the good stuff, and that's cool.
The positive side of this, we're gonna get to meet.
Right? Mm-hmm.
And put her over here.
Right. Yeah, drain the swamp.
I love you too, brother. Each and every one of you.
Love you guys too, man. Why I'm Mhm. Well, prepping for the stuff that just went out just this past week, that was the reason that I missed the event in Georgia. And I couldn't really come out and say it because of the nature of the information. But now that it's up and gone and it's before committee, and I'm sure I'm going to get a lot of questions about it. Maybe we might get some surprise visitors from staffers from the Judiciary Committee. I mean, who knows? You know, we're talking 16 hours. We've got 16 hours to be there. And if we can go in there and get them to engage, you know, that they, you know, here's our suggestions. What do you guys think? And, you know, let's put it together. You know, we don't know. You know, it might say, you know what, let me just get them on the phone and get them over here. I mean, who knows? So that's kind of what I'd like to see happen. But we don't know until we get there. It just depends on how we conduct ourselves and how well we are at getting them to engage with us.
Yep.
So
everything happens for a reason, and it's always in God's plan. So,
yeah,
you know,
I'm back in the boardroom again.
It's taken a little while to get to the calmness and be able to not, I don't know, be 20 years anymore.
Yeah.
But yeah, it's going to be exciting because it's Make America Great Again type event.
Yeah. I'm excited. So, on that note, guys, I need to go first crack my back.